Thank you all for joining this session. Today is our fifth data protection awareness session, and the topic of today is the data subject rights in research. So the General Data Protection Regulation stipulates quite some rights for the data subjects, such as the right to be forgotten and the right to object. However, these are not always absolute rights, in particular when the context of research. So in this awareness session, we will go into details of the data subject rights within the context of research. Today's session will be presented by Kurt van Espen, who is our DPO at VITO, but also acts as the DPO for the HBM4EU project. Before we start the session, I will inform you that the session is recorded, so we will make the session available, the recording, via the internal HBM4EU website, so consortium members can consult the session recordings later on when they're not able to follow. And further, I want to ask everyone to mute yourself when you are not speaking. And there is the possibility to ask questions in the chat, and the questions will be addressed after the presentation by Kurt. Kurt, the floor is yours.
Thank you very much, Lise, for this introduction. So, as usual, I will make an attempt to share my screen, and I will dig into the presentation itself. So also from my part, welcome all of you on this awareness session about the data subject rights. It's definitely one of the most inspiring parts of the GDPR. It's also perhaps one of the most complicated parts of the GDPR, at least for people who are actually doing the processing. So my goal of today is actually to give you a little bit of an introduction on these data subject rights. Maybe important to know already, and it's something that I will dig into during the presentation, is that most of the data subject rights are not absolute rights, and there is quite some misunderstanding if you talk about people who have read a little bit about the GDPR, but they are not GDPR experts. Then you will see that there's quite some misunderstandings, and I hope to be able to clarify a number of those misunderstandings here. So my goal is to give you an overview of the data subject rights as they are defined in the GDPR, obviously, to explain you how to deal with those in practice and in particular in a research context. And also at the end, I will give you some more practical tips, practical tricks actually to that could be useful to you. As usual, I will not give you a detailed legal explanation of the data subject rights, although some of you might get bored by the articles from the GDPR that I will be showing during this awareness session. But alas, that's something that I cannot avoid. We are talking about rights and we are talking about legal context here, so definitely I have to show you a few things from the GDPR itself. I think some of you will know me already, but if not, well, very briefly, I'm the DPO of VITO. I'm also acting as DPO for HBM4EU, and then that is mostly related to the hosting that we do at VITO and related to the data exchange. And I'm available for general advice, of which some is this this awareness session. I am an engineer. I'm not a lawyer, so I do know a little bit about law, which is normal as a DPO. But my main goal is actually to have a constructive approach on dealing with GDPR or privacy issues in general. I'm the managing partner and co-founder of a company called Apogado, specialized in information security and privacy. So what will I be telling you today? Well, first of all, I will explain you some general principles about the data subject rights without going into the exact details of the data subject rights themselves, but some general principles that you should take into account. After that, I will explain or try to clarify a little bit the differences between research on the one hand and public interest on the other hand. Very often they are the same thing, but also very often they're not. So I'll try to clarify a little bit on that. And that's not going to be very easy because there are different views, even from Europe, even within Europe, the European Commission, depending on who you talk to, there are some different views on that. Nonetheless, I will try to explain a little bit the difference. And then I will go into the data subject rights themselves in detail and explain you how to handle them, what they mean. So this will be a list of all the data subject rights. Some are very important for researchers, some are less important. So I will emphasize, of course, on the data subject rights that are relevant for researchers. And then finally, I will give you some last practical advice. So let us start with the data subject rights as a whole and the general principles about the data subject rights. So the data subject rights are fairly well described into the GDPR. And if you're interested, I recommend to dig into chapter 3. They're all bundled in one chapter in the GDPR, as you can see here. Now, it might be worth explaining a little bit why they are there. Well, actually, according to me, the data subject rights is actually was actually the main inspiration for drafting the GDPR, because if you think back about the old days when when companies or organizations or even governments could do about anything they wanted with your personal information, with your personal data, that definitely was a situation that we did not like, and the whole reason behind the GDPR is, of course, to give citizens, data subjects, some new rights. And the idea behind it was that that a citizen had the right to know what is being done with her or his data, who is processing this data, why this data is being processed, until when this data will be kept, and so on and so on and so on. And also give the citizen some ways to object and some rights to actually and some clarification on how to exercise those rights. So that actually is the whole idea behind these data subject rights. So I think it's very good that they are there in the GDPR, and they might be sometimes a little bit annoying for us if we are processing the data of citizens. But put yourself into the position of a citizen whose data is being processed by a retailer or by a researcher or by the government. Sometimes I'm sure that you will ask yourself questions like, why the hell are they doing this with my data, and how did they get this data, and so on. So I think that the core idea behind data subject rights is actually very legitimate. Now, as a controller or a processor of data, I definitely recommend to be prepared, because for most of the data subject rights, if somebody exercises her or his data subject right, for instance, a right to be forgotten, usually you will have 1 month. And 1 month, it seems like quite a long time, but in practice it's not. I guarantee you it's not. It's actually a very short period, because you're not alone in your organization. And that is why I definitely recommend to draft a detailed process for that. The level of detail depends a little bit on how large your organization is and how many people are appointed to work with the data and so on. But definitely make sure that you have at least a definition of the roles, that you know who within your organization you will have to talk to or will be contacted in case data subject rights are exercised. So that's very important. This is an example of a process that I've drawn for an organization which was very detailed, and even that organization was not that big. So just to give you an idea. I hear some microphones that are not muted. Maybe Lisa can exercise some data subject rights there. So another very important thing is to realize is that mostly the responsibility is coming from the data controller. I will not explain you the difference between a data controller and a data processor. I've done that in the past many times. So it means that if you are acting as a processor and you get data, you get such a request from a data subject, then actually it's not your decision. It's not your decision whether you will have to process that request. No, you will have to ask. You will have to get back to your data controller and align with them. So that's very important. So if you are a processor, please do not blindly answer any request from a data subject, but please check with your controllers. Within HBM4EU, we are acting all as joint controllers. And in addition, there is also Vito, who is also a data processor, and all these things have been detailed into the data processing agreements. Still, in practice, even if you are a processor, it might be that the data controllers have delegated this data subject rights handling to you as a processor, but that actually is different from your absolute rights to do so. So it's very important to check that and to know your role. And then something which I very often see that is being forgotten is you are obliged to verify the identity. It is in the GDPR. It is stated that it's your obligation as a data controller to verify the identity of the person making the request. And it makes sense because otherwise somebody pretending to be somebody else could actually get information that was actually not intended for him or her, and that could actually mean that you are causing a data breach. So it's very important that you verify the identity, and please do not just rely on an email address. It's very easy to spoof email addresses, as you can see here. I did not get an email from Elon Musk a few days ago, just for your information. So it's very easy to spoof all that, and you need to verify the identity. There are tools for that on the market. There are tools, for instance, there is a tool as this smartgdpr.com, which verifies identity by means of identity cards and so on. On the other hand, you should also not exaggerate, and the principle of proportionality also applies here. For instance, if somebody would exercise her rights to be forgotten when you are having this person on a mailing list. Now, a mailing list is something which is fairly innocent. So if somebody asks to be forgotten, asks to be unsubscribed to that mailing list, you do not have to verify the identity to a crazy level of detail. You do not need to do that. And you can just, I mean, if you have some basic verification for that, that's enough. On the other hand, if somebody asks right of access or the right of data portability about medical data, then of course it's crucial that you are absolutely sure that this person is who that person pretends to be, because otherwise it could lead to identity theft, it could lead to a data breach, and so on, which can be quite catastrophic and could lead to very high fines for you as a data controller. So verify the identity, but do it in proportion with the purpose of your processing. There are some derogations for member states, and it's something that during this presentation I will from time to time show you. So in particular, in the case of research, a lot of member states have specific derogations when it comes to the data subject rights. And more in particular, it's about the right of access, the right to rectification, the right to restriction of processing, and the right to object. I will dig into detail about those data subject rights themselves in a minute, but just for your information now, if you are dealing with those data subject rights, member states can actually make life easier for you, or even a little bit more complicated also, but luckily enough, usually they make life easier for you. Now, a little notice on research and public interest. Because they're not always the same. If you look into the GDPR itself, the GDPR talks about research very, very often. And in the GDPR, research is actually quite broadly defined. So research definitely is not the privilege of the academic sector. It's not the privilege of research institutes. Not at all. There is a broad definition, and private organizations, commercial organizations, any type of organization and for any purpose can actually do or can actually rely on the term research as defined in the GDPR. There is, however, an interesting document also from the European Commission, more precisely from the European Data Protection Supervisor. And they have an opinion. It's a preliminary opinion, but I don't think it has been updated since last January. I could be mistaken, but I haven't seen it anyways. But in this opinion, and you will get the link, or you will have access to the link later, they go a little bit more into detail about these differences between research as such and then research for the common good or for the public interest, which is, of course, different. One of the conclusions that they have is still that it's quite blurred, actually. And they do give some examples. For instance, if you would have a company, and there are many of those on the internet, a company that provides direct-to-consumer genetic testing services based on DNA analysis to predict medical risks or to tell you what your favorite type of wine should be according to your DNA, for instance. If you would have a company offering that, but in addition, they ask you if you would be ready to provide your DNA for research purposes, then although this company has, let's say, a facade of a purely commercial service, a direct-to-consumer service, behind it there might be a research organization. Of course, also the other way around can apply. For instance, you have a lot of, in the academic world, for instance, the academic world and the commercial sector become very intertwined. You see nowadays a lot of companies that are subsidizing and sponsoring academic research. Very often there are partnerships with commercial companies. And then, of course, this can still be very much research for the public good, for the common interest. But very often it's not. As you will probably know, non-disclosure agreements can be drawn, and in case of a non-disclosure agreement, by definition, not all the information will be disclosed. So it means that actually the results of the research are not public. They are not, or at least they are not all public. So again, there the common good, the idea of public interest and common good is actually less prominently present. On the other hand, you can also have profit-seeking commercial companies that can carry out scientific research, but of course, then very often it's not in the public interest. Interesting to know is that there is also the EU Copyright Directive, which is more talking about not about research as such, but about research organizations versus organizations that are not considered research organizations. Main point in that directive is that actually research can be done by either organization, but the idea behind the common good, though the public interest, is mostly found into real research organizations. So I think in practice, when you ask yourself, am I into research? Most likely the answer will be yes in your cases. Is the research in the public interest? That is something that you will have to look into on a case-by-case basis, and you will have to be really careful on that. Now, a little bit more now on the data subject rights themselves. Well, actually not a little bit more. This is the main part of the presentation. And I will actually handle them one by one. So this is actually a quite long part of this session, and I will try to explain them to a level that you understand it without being a lawyer. So I'll try to do that. So the first one is actually one that you're definitely familiar with. It's the right to transparent information, and it's something that you should be doing already for quite a while. It's called a right. Well, it's rather an obligation for the controller, and basically it means that as a data controller that you need to tell quite some things to your data subjects. Most of those things are pretty straightforward. It is about what are you doing with the data, why are you doing that, who is the person to contact if somebody wants to file a complaint or if somebody wants to exercise data subject rights, and so on. Also including transfers to any third countries. So I won't go into the details here, but basically it's something that you should be doing already. So it's not anything shocking here. In practice, very often we find this back in the privacy policy, which is being published online. At least if the purpose of your processing or the data that you're processing was collected by a tool, by a technical tool, or by a website, or by a cloud tool or something like that. Very often you will not do that, and you will do that, for instance, by means of an informed consent form. Well, if you are using an informed consent form, then this information obligation should be in the information notice that accompanies this informed consent form. There might be other examples, for instance, not talking about research now, but for instance, within your own organization, any employer is processing information about their employees. Well, the idea behind that, what is being processed, is something that should be made available somewhere in a kind of internal policy or a kind of legal document, something like that. So it depends highly, again, on the context, but in some way or another, you should inform your data subjects about what you are doing with their information, why, and so on. And you should do it before the processing starts. In practice, I see it often differently, but that's at least how it should be. Please do know that there are member state derogations for this. So your member state, depending on the country you are processing the data in, things might be a little bit different. For instance, in my own country, Belgium, we do have the obligation of establishing protocols in certain circumstances when you are exchanging information between two parties. So when you are exchanging information, for instance, between Vito and another party within our own country, then very often we have an obligation to the additional obligation of creating a so-called protocol. It might also be the case in your member state. Please check it. Also, one thing that I often see and people are doing wrongly or are not very well prepared for is ad hoc activities. You cannot be prepared for any processing activity. For instance, you might have an auditor entering your company tomorrow asking for a lot of data, personal data, to verify things, to verify public funding, for instance, if public funding has been done correctly. Now, maybe you were not prepared for that, or you didn't know that this auditor had the possibility to do so. So this activity might not be in your policy documents, or it might not be on your privacy policy or anything like that. That doesn't have to be a catastrophe, not at all. As long as you inform your data subjects before the actual processing takes place, you're fine. So in practice, what I do, for instance, in case an auditor steps in, that is that we actually draft an email to the people who might be concerned, and we send out an email to the people informing them about a potential new processing activities concerning their personal data. So it's not that hard, but it's good to know that these ad hoc activities can happen in your organization. Interesting also here is that, again, for and in particular for research purposes, and in case you did not get the information directly from the data subject, for instance, if your organization got data from another organization, from a hospital, for instance, that in that case, very often, in case of research, there are some interesting exceptions. And the rule of the thumb is there that if you can inform your data subjects, you should do it. But if it's impossible to inform, then actually you do not need to inform them on a one-by-one basis. It's very interesting here to take a look into recital 62 of the GDPR, particularly in case of public interest and research, because very often we are working with pseudonymized data. So it means you have the data, but you don't have any direct identifier to the data subject anymore. And it's been pseudonymized. Often we call it anonymized, but that's not the case. So it's pseudonymized data by the hospital, for instance, and you get it. So there's no way for you to contact those people to inform them that you are processing their data. So actually, what you should do then is make a kind of balancing exercise. Very often, these also are already being done in your data. In your DPIA, I have given another awareness session on that, so I'm not digging into detail again on that. But very often you have done so already, this balancing exercise. So it's very good that you did that, and then you can actually rely on that. Interesting here also is that member states can also make life a little bit easier for you. So it's very interesting, again, to look into your own country's situation. But please be careful. This only applies when you did not get the information from your data subjects themselves, but you got a bunch of information from another organization about specific data subjects. So far the right of information. Now, right of access. This is one which is in practice very often exercised actually. So basically it means that a data subject can ask you, hey, what are you doing with my information and why are you doing it? If you did a good job in the previous data subject, right, then actually this is a very easy job. Because basically, actually, you only need to tell your data subjects some generic information about what you are doing with what type of data you're keeping and what you are doing with them. But there is a catch, because in practice, the purposes of the processing can become very complicated. In research, what we very often do is that we have some data collected for a specific purpose, and then we are doing something different with it. We're doing a new type of research. And as you know, or as you should remember from previous awareness sessions, very often this is perfectly legal. It's perfectly legal because research is not considered as incompatible with the original use, at least if it's in the public interest. Okay, but that doesn't mean that you don't have to tell that to your data subject. And definitely when this type of research differs a little bit from the original purpose, then this can still become quite complicated. In a commercial context, this can really be a nightmare. For instance, suppose that you have a loyalty card for a petrol station. Of course, your loyalty card or information, personal information on your loyalty card is used for a lot of things. It's used to give you a discount when you are getting your petrol, or to get a little present or something like that. But also the petrol company will use that to determine which is your favorite petrol station. Maybe they will send you some publicity. Maybe they will give you a discount at a large retailer. I mean, in practice, and I've worked for such a petrol company, there are hundreds of purposes of processing. So in practice, this can be very, very complicated. So definitely for this right, you should be prepared. The good thing is that usually you should only do it once, because most of the processing will be the same despite what data subject it is. I mean, or at least for each type of data subject, it's the same answer that you can give. So it's a one-time, it's a kind of one-time job usually. That's the good thing. But still, it's quite a complicated task here, and definitely one point of attention which I see in practice that often is forgotten is that if there are international transfers, you should definitely be prepared to explain which mechanisms that you are using to safely transfer your data outside of Europe. When we're talking about international transfers in terms of the GDPR, I mean outside of Europe. So, but still, we have the UK, we have Israel, and so on. So in many cases, it does apply actually. Again, here there are member state derogations, and the good thing is that for scientific research, regardless whether it is in the public interest or not, usually life is made easier. So that's a good thing. So definitely worth looking into that in your country. Another one is the right to rectification. And the right to rectification is actually, it's less spectacular. It's actually quite self-speaking. What it means is that if something is wrong, if some data is wrong, that the data subject has the right to rectify that. So it's actually quite self-speaking. It makes sense. The only thing is that technically it can be very challenging. Maybe not so much in research, although if you have distributed databases and so on, it still can be, it can be quite harsh. But imagine we have our loyalty card and Mr. Jones becomes Mrs. Jones. So it means that actually Mr. should be replaced by Mrs. in maybe hundreds of IT systems. So in practice, it can really be very, very challenging. And again, this shows how important it is that you do not process any information that you do not really need. That's not the topic of today's awareness session, but I've told it in earlier awareness sessions. If it's the principle of data minimalization, so you should really stick to that. Only process the data that you need, because you will only get into trouble. I mean, not only will you be doing illegal things, but you will also get into big trouble when people exercise their rights. In the context of research, there are again some member state derogations possible. And think about a situation here in research. Suppose that you do a research on smoking or drinking behavior, and you have done a quite elaborate study. You have published papers and so on, and then somebody exercises his right to rectification. He says, actually, I was not drinking 10 beers a day. I only was drinking 8 beers a day. So I exercise my right to rectification, and you should change your study. You should change all your results. Of course, you can imagine that this is very, very difficult in practice, and this would be very impractical. So again, there are member state derogations that allow you to actually ignore that stupid request. So there is also the right to be forgotten, and the right to be forgotten, that's probably the one that you are most familiar with, the right to erasure. It's one of the basic principles behind the GDPR, actually. But there is a big confusion, because the right to be forgotten is far from an absolute right. It's definitely not something that is there as an absolute right. And the example that I probably have given already before was, if I exercise my right to be forgotten at my taxman, then it will not work. My taxman will nicely tell me that he will not or she will not forget about me, and I will still get to pay my taxes. So the right to erase, the right to be forgotten is actually only applicable in specific circumstances. And the circumstances are listed here. Well, the first one is pretty obvious. It's when, okay, if you do no longer need to process that information, then it's, of course, it makes sense that somebody can exercise the right to be forgotten. Also, when information was given to you or is processed with consent as a legal basis. Now, today's awareness session is not about the 6 different legal bases in the GDPR, but you probably do remember from an earlier awareness session that consent, in particular in the case of research, is not always the most ideal, legitimate legal. It's not the most legal basis. So definitely, I recommend to consider another legal base than consent, because actually that might make your life much easier when to prevent that somebody exercises his or her right to be forgotten. The other ones are less interesting, or they are very straightforward. For instance, if you're processing data in an illegally, of course, it makes sense that somebody can request that you can request to be forgotten. Again, here there are member state derogations, but I have looked into some of them, and I did not find any which was really directly related to research. They are more related to freedom of expression, they are related to the world of journalism, for instance, these kind of things, and sometimes also to technical constraints. So a little bit less interesting for us. Let me take a look at the time. Okay, we're doing quite well, but I always say that, and then at the end I run into a problem with timing. Also interesting to know about this right to be forgotten or right to erasure is that, again, there are some very interesting exceptions for scientific research, and that, of course, makes quite some sense. Think about peer reviews of research, think about situations that would really make your research impossible if somebody would actually request the right to be forgotten and so on. So in terms of research, you're actually quite safe when somebody exercises that right to be forgotten. Please do check it with your DPO, however, because in some cases the right to be forgotten still applies. Another one is the right to restriction of processing. Now, the right to restriction of processing is also, it's actually also not so spectacular. It basically means that the processing should be put on hold, and it makes sense. For instance, this right can be exercised when somebody exercises another right, and this right needs to be investigated. For instance, somebody would exercise their right to be forgotten, and you are actually in the process of investigating if this right indeed needs to be exercised or not. Well, during that right, then actually somebody can exercise a different right, which is like, okay, please do your work. But please, in meanwhile, I would prefer that you are not processing my information, put it on hold. Again, there are member state derogations for scientific research. So in case of scientific research, you should actually not really be bothered. In practice, I have never seen any problem with somebody exercising this right. Maybe in the coming years it will happen, but in practice I don't think this is really much of a trouble. One which could be a pain is actually the right to data portability, but again there is a lot of confusion. The right to data portability, it actually means that as a data subject you could ask somebody who is processing your data, you can ask them like, give me back all my information that I have been giving to you. Now, and I definitely recommend you try that on Facebook. If you have a Facebook account or a LinkedIn account, I didn't try it with LinkedIn, but I did try it quite often actually with Facebook. So if you go to Facebook, there is some very well hidden. There is a kind of button that allows you to exercise this right. And then if you exercise that, then Facebook will actually give you a big bunch of data, which is basically anything that you have put to Facebook yourself. So it's about likes, about comments, about statements, about check-ins, all these kind of things that you are happy to share with the world. So all this information you will get back from Facebook. The confusion here is that sometimes organizations think that you have to tell anything to the data subject, but that is not the case. That's very often not the case. Actually, the only thing that you need to tell them is the information which is related to processing based on consent or based on a contract that you have. Facebook probably knows what type of food that you like. And Facebook probably knows, maybe even better than yourself, what political party you should vote for. But Facebook will not tell you that, because they are not obliged to do that. And of course, it makes sense, because that is a kind of intellectual property that Facebook has built up based on your data. So the biggest misunderstanding here, to summarize, is that organizations think they need to provide anything, but that's not the case. It is actually limited to personal data which was provided with consent or which was necessary for the contract and which was processed in an automated manner. Still, it can be technically extremely challenging when somebody exercises this type of rights. It's usually it can actually take up the entire budget of your DPO for the year if somebody does that. So be prepared. And then one other one is the right to object. Now, the right to object, this is actually more related to processing of data based on legitimate interest or in the public interest. Why am I listing it here? It is it is a right that somebody has, and it does apply for research, but not if the research is in the public interest. So I don't see this right to be, I don't see this right exercised very often, but if it happens, please check that with your DPO, because in many cases it will not apply in your case, but still it might be. It depends on your particular situation. It's usually related to profiling and processing based on a legitimate interest, not based on consent, for instance. And again, there are member state derogations also for research, which is a good thing. If you do process your information based on legitimate interest and not on consent, then you should know that already from previous awareness session. You should be able to demonstrate that you made this balancing exercise, that you were not infringing your data subject's privacy more than necessary. That's just as a side note. Finally, there is the right to, and I would call it not to be subject to individual decision making. I think that is less relevant for us here, but basically it means that it's very relevant, for instance, for insurance companies that would calculate your insurance fee based on your risk profile. In that case, then actually you have a right to object to that. It's not an absolute right, and again, there are member state derogations for that, but I didn't find any which are directly related to research, so I don't think it's worth digging into details here. Of course, if you have questions on those, you can always ask me. Finally, some practical remarks. So I have now summarized all the data subject rights, and I think I have emphasized which of those are relevant for research and or in the public interest. But some practical remarks. First of all, I already said it, it can be very time consuming. And although you have 1 month, it is a very short time. So when preparing for that, you probably do have already within your organizations, or at least you should have already quite some instruments. You probably have done a data processing impact analysis. You probably have a register of processing activities, at least you should have one. And these instruments, they already contain quite some information. Do not rely on your DPO alone. Your DPO will guide you, but your DPO does not know where your information resides and what your individual purposes are. Your DPO will tell you, like, okay, take a look into your register of processing activities, or will perhaps guide you in terms of this request is stupid, you can answer this, and he will guide you, or she will guide you in terms of answering and communication with your data subjects. But content-wise, your DPO does not know what the exact processing activities are. And in particular, if you are dealing with many parties, for instance, if you are working with joint controllers, as we are, or if you're working with processors who in turn have sub-processors, then it can be very, very time consuming. So you should be prepared. Also, please do realize, if your data subject rights, if exercising a data subject rights by someone would infringe the data subject rights of somebody else, then you should not exercise those. For instance, it could be the case if somebody asks their right of data portability, but in the information given by that person, there would be personal information about other people. It can be the case. So if that is the case, then you should be careful and not do that blindly. Now, what do you do in case your data is anonymous? Well, it's very easy. By definition, anonymous data is not personal data, so it's not subject to the GDPR, and the data subject rights, by definition, are not applicable. However, if you followed my awareness session about anonymous data, then you should also know that in practice, truly anonymous data is very, very difficult to achieve. In practice, it will be only achievable if you aggregate data to a quite extensive level and so on. So in practice, it's very difficult to claim that your data is anonymous. By most, your data will be pseudonymous, and here you see a table of HBM4EU data which has been made pseudonymous by one of the various ways that are available. Now, in case of pseudonymous data, if you get a request, well, the first thing that you should tell your data subject is like, well, I wish to help you, but I can't. And it's a good thing that I can't, because I don't know what data I have of you. You might claim that I have your data, but I don't know it. So only if the data subject insists, like, yes, but actually that guy born in 2016, it will be a little kid, but take another example, somebody born in 2000. Oh, sorry, there was a glitch here. So if somebody says like, okay, but that particular row, that is me, then first thing that you should ask is proof that it's you, and then only then consider exercising these data rights. So do not blindly re-identify the data subject, but try to get around that. Also, please do know that data subject rights are often exercised by disgruntled people who are not happy for one reason or another. Very often the requests are very legitimate, but very often actually they are based because somebody was unhappy. Governments get these requests all the time nowadays about people who are angry because they had to pay an additional tax and so on. So they ask to be forgotten and these kind of things. So if you do get this type of request, please do not be tempted to answer in an angry way or something like that, because actually I have seen that sometimes this can result in an official complaint at the Data Protection Authority. Should you interact with those angry, disgruntled data subjects, or should you just stick to the official communication? I leave that up to you. I would say that's a case-to-case basis. I have had experiences both ways. Sometimes people are very happy when they get an email from the data protection officer asking them, telling them like, okay, we will help you. You have absolutely your right to be exercised, and I will help you on that. And they will be actually very positive because of that reply. And you still have to, of course, take into account that they exercise their data subject rights, but it will be in a quite relaxed way. On the other hand, some people are not happy with that, and they will not answer you. And if you did not reply within 1 month, they will file a complaint. So it depends a little bit. I think that's more psychology than science here. So that brings me to the end of this awareness session. Thank you for listening.